My most important goal in both running for Honolulu Prosecutor and then becoming Honolulu Prosecutor is restoring trust to this office. That's why I made it the #1 goal in the 100-day plan when we had the press conference back on January 12th. It is still my primary goal, and I will be discussing in more detail along with the other 9 goals for the office and following up with that. However, based on recent events and our efforts to look at all of our practices and procedures, and to restore trust to this office in particular and the criminal justice process in general, I would like to address the 2 recent officer-involved shooting of civilians on Kalakaua and in Nu'uanu. In the past, HPD would investigate all officer-involved shootings. They would do the investigation and then forward their conclusions and recommendations to the prosecutors, often a process that took more than a year. This is not to say that HPD did not do a thorough professional job in each case. They have fine, dedicated detectives and investigators. They know what they're doing. This also is not saying that the prior administration at the Honolulu Prosecutor's Office didn't make the right call in whether or not to charge someone. But this is a new administration, and we are looking at all of the practices and procedures, and we are going to do things differently. Whenever you have an agency that is involved in the shooting, then responsible for investigating that shooting, you are always going to have the perception among some that it's not appropriate, and thus their final conclusions and recommendations may be suspect. And I believe it is critical to have an independent but thorough, objective investigation into both of these cases and for any future police-involved shootings of civilians. To achieve that, I am assigning teams of seasoned prosecutors and investigators to each separate shooting incident involving civilians. They have extensive experience both in the state system and the federal system to investigate each of these recent cases, starting with the one in Nu'uanu and on Kalakaua. We have requested, and HPD has been very cooperative and have sent us all of the evidence collected thus far, and will follow through as if more evidence is collected in the future going forward. That includes the body-worn camera footage, police reports, and the like from both of the shooting incidents. We at the prosecutor's office will evaluate all of that evidence, as well as any other evidence we gather as part of our independent investigation. And that would include further interviews, that could include documents, subpoenas, any grand jury information. We will proceed with an expedited, but at the same time, deliberate and thorough review of each of these cases, and make the decision to decide whether any criminal charges are warranted. Regarding any evidence that is collected, we will not be releasing any of the evidence collected by HPD or our office to the public or the press during this investigation. That includes any body-worn camera footage or any police reports. Now, each law enforcement agency or department operates under its own policies and procedures in this regard. As the Honolulu Prosecutor, I am bound by codes of ethics and rules of professional conduct, and will always have to be cognizant of my responsibility not to improperly influence or poison any potential jury pool. And releasing evidence like body-worn camera footage or investigative reports prematurely could have just that effect. I'm going to follow the same procedure in these cases I have followed in all cases since I was elected and sworn in as Honolulu Prosecutor on January 2nd. It's also the same procedures I followed during my years as the United States Attorney. This procedure was followed in the successful investigation and conviction of the United Public Workers head Gary Rodriguez. It was followed in the successful investigation and prosecution by Honolulu Police Department Sergeant Clyde Hayami for violating arrestees' civil rights, also in the investigation and prosecution of the Poly Golf Course shooting, and most recently by the federal prosecutors in their successful investigation and prosecution of former Police Chief Louis Kealoha and of former Prosecutor Supervisor Catherine Kealoha. In all these cases, the prosecutors made a conscious effort not to do anything that might influence or poison the minds or opinions of any potential juror and cause them to prejudge the case or the evidence, either for or against either side. From my 15 years as a circuit court judge on the criminal bench, I held it dear to my heart that my obligation, in order for the defendant and the state to have a fair trial, you had to have the jury pool, the potential jury pool, as untainted as possible. That is essential. Now, I realize there is intense interest in this case, both among the press and the public. And I recognize in an ideal world, it would be the best thing to have a totally independent entity set up to investigate and look into these cases and recommend any potential charges for any officer involved shooting of civilians. That entity should not be answerable to the State Attorney General's office, to the Honolulu Prosecutor's office, or to the United States Attorney's office. It should be staffed with seasoned prosecutors and investigators who not only have extensive experience doing homicide cases, but also are up to date on current investigatory techniques and practices. They'd be responsible for collecting evidence, interviewing witnesses, sending out subpoenas, using the grand jury to do a complete and thorough investigation of any officer-involved shooting of civilians. But we don't have any entity like that now. And until the day comes that we have it, we at the Honolulu Prosecutors are in the best position to do this. We have a strong makeup of experienced prosecutors who have done dozens of homicide cases, both in the state system and in the federal system. This is the place to do a thorough and complete investigation and determine if any criminal charges should be brought against anyone. I was elected by the people of the city and county of Honolulu to serve them, and they will be able to judge my performance and our office's performance in doing that. Any questions on this? Yeah.
Steve, has the police department said that they will turn over every stitch of evidence they have of the officer-involved shooting, or can they withhold some of it from you?
They are turning over all of the police reports, the body-worn cameras, and everything else. There may be certain parts to it that when they do their own internal investigation that involves, pressure on the officer for an administrative matter, that has not been decided. And I would not expect that right now. We are in the process of looking at the whole thing. We understand that's a separate part of it. They need to find stuff out right away. They have to do their own internal investigation. But they have been very cooperative about turning over all the evidence that's been collected at the scene, body-worn cameras, all the rest of it. That they have sent that over in the last couple of days.
Are you able to take statements from the officers directly?
We will be doing this as an independent investigation. If we think there need to be any follow-up interviews, interviews of people that haven't been interviewed, that have been interviewed already, we will do that. That's part and parcel of an independent investigation. Yes?
Prosecutors were banned from the scenes of police shootings in 2018, according to your first deputy. Will prosecutors be returning to those scenes now?
That's something, right now we're focusing on these two cases that are currently here. We are going to be looking at all of the procedures going forward.
Were prosecutors at the scenes of those two recent shootings?
Not that I know of. Not from our office.
I know that you want to have a thorough look at this, Steve, but any idea on how long the investigations could be?
I don't want to put a number on it, but as I said, this is important. It's important to the police. It's important to the prosecutors. It's important to the public. So it will be expedited, but at the same time, thorough and complete. We're not going to rush it, but we understand the importance of it. And as I said, we are putting our best people on this with separate teams for each of the incidents in order to get this done right.
Have your prosecutors already interviewed the officers involved in?
I'm not going to talk about as I said, I'm not going to talk about the investigation into this case, the pace of it, who's being talked to, what's being done. That's part of the investigation. And I realize that may be frustrating to people. This is the way I have always operated, whether I've been working with the police department in the past, whether I've been working with the federal agencies. An investigation is just that. It's an investigation. And when it's done, that's when we can make conclusions. And if there's a trial, evidence will come out at that time. And right now, it's still under investigation. Yeah.
Do you see a time after completing your investigation where you'll eventually release the SICAP body cam footage?
Have not decided that.
If you decide not to charge, will you be publishing a public report?
Again, the typical routine when I was the United States Attorney is you try not even to confirm or deny that an investigation takes place.
I mean, once it's
Hang on a second. And that prevents somebody from being, just mentioned, because that can tarnish their reputation. And then if we never find enough evidence, we just leave it alone, and hopefully that doesn't sully their reputation. There are exceptions, and have been exceptions in the past, when something is of such public interest that it may be appropriate to discuss it. So that is being considered.
With regards to body camera footage, at least with the SICAP case, the Honolulu Police Department has said, we can't release it because it's a juvenile. Do you have an actual legal opinion on that, or do you think if they wanted to, they could release it?
I am leaving that up to the police and their lawyers to examine the statutes and decide.
Would you release
We have
that
our
as
own
part of it?
kuleana in this. We're not going to release any of the body cam footage, whether it's adults, juveniles, anybody, because it's part of the investigation.
If you want, you mentioned, at least doing the independent investigation is to build transparency. Is part of that, releasing the body camera footage? Is that, you mentioned tainting a jury pool or et cetera, but would just body camera alone, is the public interest outweigh that?
Having a fair jury pool so the defendant can have a fair trial is paramount. Because anything that's released ahead of time, depending on how it's released, who reports on it, who opines on it, can cause potential jurors to prejudge the evidence and the case. That can never be recaptured. As you say, it is of interest, people want to know, but part of this is, I was elected as Honolulu prosecutor. Our job is to investigate and charge cases. If anyone's going to get charged in this case, it's going to be by us. So it makes sense for us to do the investigation. We would just ask people to be patient, give us a chance to do the investigation, and then see what happens after that.
So,
Yeah.
so have you asked HPD then going forward for any officer-involved shootings to not release any body cam footage, period?
We have not said, as I said, each agency has their own criteria, interest, and I've seen that in other places where a mayor may want to release it, but that's the mayor's, if he or she is under that situation, but that's not my kuleana.
So if HPD decides to release footage going forward, you'd be fine with that, but your office won't?
I'm not saying I'm fine with it, I'm saying it's not my kuleana. We would not, as prosecutors, we are held to a standard of not influencing the jury pool, not poisoning the jury pool, not making it harder to ever get a jury if anything does go forward. And having jurors see selected things released by selected people and so-called experts and they're opining on things just creates the opportunity for people to have prejudged the evidence and this case in some way. We're trying to avoid all of that. We are moving, as I said, expeditiously, but at the same time thoroughly and deliberately so we can do a good job.
We have instances, but how many people are on each of these teams? And
I'm not going to give the details, but rest assured it is our experienced people with a separate team assigned to each of the shooting incidents. We have 3 teams that will be, if needed, looking at these going forward.
In general,
that started today, or he started that?
It has started very recently.
Do you feel that maybe there should just be a strict policy that be implemented as far as when it comes to body cam footage or 911 calls, that a more sort of specific policy of what can be released though?
You mean from everybody?
Yeah.
Well, it would be more predictable for you folks. It would be more, predictable out there. But I really can't speak on behalf of other agencies. I don't feel comfortable doing that. I don't think they can speak on my behalf. I don't think I can tell them what to do. Consistency is always something to be valued. But I don't want to try to speak for any other agency.
can you speak in general, just across the country, just in light of a lot of these national cases? I mean, there have been more cases recently where officers are getting to the point where it is brought to trial. Just I know you're still investigating, but just in general, in your mind, what level do you think it rises to for an officer to actually be charged in a case like this?
Oh, I think any time an officer is charged with a crime, it's important. When I was the United States Attorney, we got information that a sergeant was violating the civil rights of arrestees. We worked with the FBI, we worked with the Honolulu Police Department, we investigated that case, and Sergeant Hayami was convicted and sent to more than 5 years in federal prison. So it's very important. And the police supported it. They know if people in the police department are committing a crime, they should be held responsible. Nobody is above the law. And that is regardless whether it's a prosecutor, whether it's a police chief, whether it's a police officer, whether it's a union member, no matter who it is in our city, whether it's a city council member. We did a lot of political corruption cases when I was the United States Attorney. Nobody is above the law.
Steve, what do you make of concerns that city prosecutors have an inherent conflict of interest because they have to have a good working relationship with HPD?
Well, I think that's an issue. It's always going to be there. We do work with them. They're our main partner in everything we do. They investigate most of the cases. And I think the answer to that, very frankly, is I wish there was a separate independent unit that was stood up. But understand, that's not going to be the easiest thing in the world because you've got to get experienced people who are actually current at doing what they're, with investigative techniques. But that would be the ideal. And we just don't have that here. And I notice in some states, they have like a Bureau of Investigation, like an FBI for the state. So it's a natural for them to have a different police agency do it, come up with recommendations. We don't have that now. So, in an ideal world, we would have that. And if we have that, then let's let them do those investigations. But in the meantime, we are the best situated to do this. And so we're taking it on as part of our job and part of our responsibility to restore trust for this office and the criminal justice system in general.
When your prosecutors question an officer, do they have to read them their Miranda rights?
We're not going to talk about any of the investigations again because this is all, we're holding it close to the vest because it's an investigation. We're not going to talk about it today. If you call up next week, how is the investigation going? It's going to be the same response.
I was just talking about the process generally.
I understand, and that's my answer.
Why did it take more than a year, Steve, for, you said early on, to get the information that you needed
Well, it wasn't me. I wasn't here.
for the office?
So the prior administration, however it was decided, that is the procedure they had with HPD. I can't speak to HPD's process then. They do have experienced investigators. You know, they're being deliberate, they're following through with it. I can't speak for the prior administration here about whether or not they liked that procedure, didn't like that procedure, but that was the procedure. So I'm just saying that I'm new here, we're going to do things a different way, and I think when things are done faster, you know, it restores public confidence. And part of that is doing it, you know, and I don't think it's inconsistent, but doing it in an expedited manner, but being thorough and deliberate to it at the same time. So this is how we're planning to do it going forward.
What happens in the case that HPD doesn't want to provide the information you need?
I have no doubt they will. We are their partners in this. We are their partners in investigating all other cases that need to be investigated and then prosecuted in the city and county of Honolulu. I have every confidence. They've already been cooperative. That cooperation will continue.
See, if multiple officers are involved in a fatality, will they be separated and separately interviewed?
That is typically what happens in most situations. Again, I'm not going to talk about the specifics of this case, but when there are many witnesses in all sorts of cases, the typical process is that. Okay, now I know you've been, we had a press conference 3.5 months ago, and we talked about the 100-day plan. We've given you some information so you can follow up with that. I just want to highlight a few parts of it. Number one has been and is restoring trust to the prosecutor's office. We've talked to all of the deputies. Berger versus United States is the classic case of the role of a federal prosecutor and a local prosecutor. I have met with all of the deputies in this office to talk about ethics, to talk about, I have a zero tolerance for any sort of misconduct, any sort of sex harassment, bullying, and the like. We're setting high ethical standards. We're doing trial skills training. I talked to Chief Justice Rechtenwald. They are going to give us a week out of court so we can do training for all of the deputies in the office. The public defenders have been doing this for like 20 years. So my smart administrative team said, why don't we ask for the same thing? So I did, and they said fine. Because they know the better trained the prosecutors are, the better they're going to be in court to do things. That will include great training. During the campaign, I was asked by a lot of the good members of the defense bar, hey, if we can help with training, we'd love to do it when you get in, if you get in. And so we're going to have some of the cream of the Hawaii bar helping with that, as well as the talent in the office. We are going to continue to tap the expertise of our 6 division chiefs who have a combined total of 146 years of trial and prosecutorial experience. We get their opinion and feedback on promotions, transfers. They are now on all of the hiring committees for the first time ever. Whatever division the new deputy is going to go into, that division chief is on the 3-person hiring team. Most of the new deputies are going into the misdemeanor division. We are fortunate to have former United States Attorney and 32-year federal prosecutor Florence Nakakuni as head of that division. So she's part of the hiring panel. She has already started trial skills training there. And I really like being able to tap Tom Brady as our first deputy because he was here for 7 years, then 26 years as a federal prosecutor. We're trying to pick and choose the best techniques and strategies from both the state office here, the Honolulu Prosecutor's Office, as well as the federal method of doing certain things, and I think it's really going to help. We are trying to increase transparency. We understand that's really important. So we're making it as open as possible. We have met with OHA, we have met with the ACLU, we have met with immigration attorneys. We are going to be trying to identify the racial groups of all of the people that are being charged. We're working with HPD on that so we can see who's charged, who's convicted. You know, I know when I was here before, there was an effort not to do that because nobody wanted to be accused of targeting any race. But we realized the world is different. People want to know, are different racial groups being treated differently for whatever reason? We have already started the management audit of Kathy Kaloa's cases. Tom Brady is leading that up. Chris Van Marter is assisting him. We are interviewing people, looking at things. They have found files that were signed out to her in places that should not have been found in this office. They are being followed up on. We're addressing the audit of the prosecutor's office that was done. The conflict of interest policies have been implemented. So for every case, there's a conflict form the deputies have to fill out to verify that they don't have a conflict, their family doesn't have a conflict, and their supervisor has to sign it. We've worked on making sure our felony plea agreement procedures are standardized, post-case evaluations. We are still working on written procedures for handling of any internal complaints. A big part of things is working with the judiciary and the defense bar, HPD, public safety, and others to bring innovative solutions to the COVID crisis. Part of that was when we identified that the same person was committing multiple sex assaults in the 4th degree cases, grabbing women's breasts and buttocks. We identified it, we issued a warning to the public. We knew the person had been released because under the Supreme Court order of last August, the district court judge had no choice. They had to release them for any misdemeanor and petty misdemeanors. But as you know, some misdemeanors can be serious. A sex assault in the 4th degree is serious. An assault in the 3rd degree is serious. You can be beaten black and blue, but if it doesn't break a bone, it's still an assault 3rd. So we filed that motion, and let's be clear, we are not trying to go back to the pre-COVID days of filling up OCCC with misdemeanors. We are not asking for bail in many cases. What we asked for was the ability on a selected case-by-case basis to ask the judge for bail. Some of the time that would be to hold the guy in custody. That's what we tried to do and ended up doing with Mr. Jacob. The Supreme Court was very open to our motion. They granted it and then said to all the parties, tell us your paperwork within a week about lifting all of the restrictions. And they did that. They terminated their order because there are some voices that have said nothing's changed at OCCC. That is totally untrue. The Supreme Court responded to a crisis last August. There were 299 people positive for COVID at OCCC. Since then, they've implemented a robust testing program for anybody new coming in. They have them in isolation for a day. If they're negative, they can go to general population. If they're positive, they quarantine them. They've been offering repeatedly to all the staff to get the vaccinations. Back in August, they didn't have testing, they didn't have vaccinations. Now they have both. Every defendant, or virtually every defendant, there's always a little movement in and out of jail, has been offered the COVID vaccine. So the situation is different. There are 0 positive tests as of today, is my understanding, at OCCC. So we, on a case-by-case basis for both felonies and misdemeanors, will be asking for bail. I really care about the inmates. I would match my record at helping people in the criminal justice succeed on probation and not go to prison. Or when I was head of the Penal Code Review Committee and we got rid of mandatory minimums for drug possession charges. I am a big believer in helping people in the system to get help, but at the same time, I also care about the public. And you can do both. So vaccinate the folks inside, but we've got to get that system rolling again. And opening up the courthouse, we would encourage that to happen so probation can get back to running the way it ought to run. They are doing some drug testing, but it's very limited. We need drug testing to help the defendants stay clean. In Hope Probation, most of them were able to stay clean because of the drug test. If they're not getting drug tested, that's not going to happen. So we are in the business of working with the judiciary and the defense bar to do jury trials. They're trying to work out procedures. They were hoping to start with a murder case. They've been doing single defendant cases since December, and the judiciary has done a great job of that. But the next phase is trying to do murder cases or multiple defendant cases. The only court system that has operated as normal since COVID started is, from our office, juvenile offender cases out at Kapolei, because they're judge trials, people can be socially distanced. Huge backlogs in both district court and circuit court. in order to address the backlog of DUI cases, our office worked with the defense bar, different members of that, public defenders, private counsel, as well as consulting with community groups like MAD about coming up with an alternative for first offender DUI cases, not arrested before. And that would allow them to plead guilty to a reckless driving. They'd have to have the interlock ignition for a year or not drive during that time, and the other typical considerations, $1,000 fine or community service. So far, 1,013 defendants have taken advantage of that. I consider that a very important step because, as MAD understood, many of these cases would get dismissed because they were not going to be able to be brought within speedy trial guidelines. So the next thing we've really tried to work on is career development of the deputy prosecutors. In the past, with the prior administration, it was an assignment by judge. That means like 3 deputies would be assigned to a specific judge, and all of their cases, all of their jury trials would be with that judge. It might be more efficient in some ways, but it hinders the development of that deputy prosecutor. They should have to be nimble, they should have to be flexible, different judges are going to demand different things, and for good career development, our deputies have to do it. It does mean running back and forth between courtrooms. That's life. That's what circuit court is all about. From now on, after misdemeanors, they're going to do a rotation in family court, and that's the juvenile offender unit. This will give them a chance to screen and take felonies to trial in the family court setting. Florence Nakakuni has already started the trial skills training for the deputies in that courtroom. And as I said, we coordinated with Chief Justice Rechtenwald about being out of court for a week in May so we can do extensive trial training for where people are in the system. If they haven't done a jury trial yet, that's a several part in court or in a breakout room training with our top deputies doing the training with volunteers from the community playing part of witnesses. Another group maybe have 1 to 10 jury trials under their belt. And then another group has more than that. First Deputy Tom Brady has started roundtable case reviews with the deputies. Deputy comes in, presents an upcoming case they have. They get all sorts of suggestions. Have you thought about this? Have you thought about this? Why don't you try this? This is tremendous for career development. The deputies that are there can do that. They can participate in it. They will learn from it. It's a supportive environment. We are here to help make our deputies the strongest they can be. And we've already been hearing a lot of positive comments. We have hired a lot of good new deputies. We've worked it out with the city to bring a few on every month with this COVID crisis and the budget crisis. But we've been getting positive feedback from the judges about the new deputies and how well they're doing. Number 6, we are continuing to strategize on sending the truly violent, or trying to send, the judges make that call, the truly violent and dangerous and those who won't stop stealing to prison. This is tremendously critical to keep Honolulu safe. And I know from my time as a judge, I hated it when the attorneys wanted to see me before the sentencing and the prosecutor would say, you know, Judge, this guy should be on probation, but you know my office, I have to ask for prison. Those days are over. We're requiring more of the deputies. We want them to look at the cases on an individualized basis. If the person's violent or dangerous or won't stop stealing, ask the judge to send them to prison. Not everybody should be on probation. That's probably 35 or 40% of the defendants at sentencing. But they should be going to prison to protect public safety. But that means the other 60% can and should be placed on probation. And we now have proven strategies, and I was the rare judge and probably the rarer prosecutor who believes in looking at data and research to drive criminal justice policy. But we have drug court, we have mental health court, we have hope probation. We all succeed when people on probation succeed. You don't want to send a 20-year-old kid with a little cocaine in his pocket to Halava prison. You should help that person to get rid of any drug problem they have, get a job, get in a relationship, and not commit crimes in the future. That is public safety too. But we don't want the judges to see us as a broken record, so we're going to individualize, and part of this is is training. I can tell you, when I was here as a deputy prosecutor, we thought 26 years ago, we thought our job was to send everybody to, and many people to prison for as long as possible. Well, those days are over. And especially from my time as a judge, I realized some people absolutely need to be in prison to protect public safety. Others can and should be placed on probation. But that's why when we just indicted the two SICAP brothers for the incident that happened near the scene, we made it very clear, based on protecting the public, deterrence in the future, we will be asking for prison if we can convict those guys and sentence. So I just want to, be very out front about that. I want the judges to know, whoever gets this case, we will be asking for prison in those cases to protect the public. So to me, some people think you got to send everybody to prison. Others think you got to let them all out. I don't think either one is smart. You should identify who can and should be in prison and do your very best to send them. The other folks, you identify, let's get them on probation, let's get them successful so they don't commit another crime in the future. That's public safety too. So I think if we individualize it more, the judges hear that our deputies are actually looking at the cases and making individual calls on it, maybe they'll listen to us more. And when we're asking for prison, give a serious thought to sending folks to prison. And when they're in prison we've got a good prison director now, Max Otani. Hopefully they can get more funding, they can do treatment programs, they can do educational programs. When I talk to inmates and they tell me I'd rather go to Saguaro, even though I'm cut off from my family because this other prison up there has all these programs. That to me is crazy. We should be taking care of our own inmates and try to help public safety rehabilitate them in there so when they come out, they don't commit another crime. That's good for public safety too. I am meeting with all the law enforcement agencies and departments to coordinate efforts. I've met with the Attorney General, I've met with the police chief, I've met with the neighbor island prosecutors, the United States Attorney, the FBI, DEA, NCIS, Naval Criminal Investigative Services, High Intensity Drug Trafficking Board, and the head of public safety on more than one occasion. I have emphasized the Honolulu Prosecutors is back as a full partner. We will be cooperating with people. We'll try to work together on that. We have resumed data sharing with the Criminal Justice Information System after 7 years of no data exchange. This cooperation will help the quality of prosecutions for juvenile offenders and make it available to the police, the courts, and the other counties. We resolved major case disposition omissions that affected the Criminal Justice Information System. Rap sheets. 27,000 unresolved contempt of court cases have now been resolved. And we set up procedures to ensure that hate crimes are tracked. HPD will look at it. They may think there's a hate crime somehow involved in it, send it over to our office. The Attorney General's office tries to track this. And so we're making sure we're in communication with that to say whether we proceed with it as a hate crime or not and why, but make sure we account for all of those cases. And I really do, we are trying to reorganize and reemphasize certain types of crimes. I recognized from the beginning that the white-collar team was too small here. In particular, HPD had started a cyber crimes task force last year with detectives assigned to it. They are doing a lot of search warrants. Chris Van Marter heads up the unit. When I came in, there was 1.5 deputies assigned to it. Now there are 4. This is an important area. White-collar criminals need to be prosecuted and in some cases sent to prison. Nobody is above the law. We are emphasizing investigating and prosecuting sex trafficking cases. Part of our job is to send pimps to prison. When I was U.S. Attorney, we prosecuted 7 pimps for bringing adult women across state lines under the Old Man Act for immoral purposes. I can tell you when they were prosecuted, it gave the women that were enslaved to these folks a total of about 6 or 7 years free from this pimp so they could chart a new course, go back to their old life. I got so many calls from all the security heads in Waikiki because Whatever the pimp was involved with that, they were involved in all sorts of other criminal activity. So we will be taking a broad look at this. We identify them. If we can convict them of sex trafficking, that's fine. If we convict them of drugs, assault, anything like that, we will do it. We will try to make Honolulu an inhospitable place for the pimps. At the same time, in doing research and learning more about this, a number of people are introduced into the sex trafficking trade by their families. Like 25% of the cases. That is appalling. That is sickening. And people should understand that's where a lot of this is happening. Your kids, you want to protect your kids, keep them away from this. Part of it is education in the schools, and Rochelle Vadina, our head of our sex crimes unit, sex assault unit, is going to be working with the different agencies, Susanna Wesley, Ho'olanapua, to go into the schools, to warn the kids, junior high kids, middle school kids, if you get invited to a party and an older guy is paying attention to you, be on your guard. He may well be a pimp. He's going to pretend to be your boyfriend, want to give you gifts, take you out. In a few weeks, you're going to find yourself working in sex trafficking for him. And the most at-risk group are runaway girls. And whatever we can do to try to help that, we are. We're trying to work with whoever's out there to make sure this gets done. We are beefing up the Family Prosecution Division that handles all of our domestic violence cases so we can be more effective in that area. We are engaging the community to solve problems. We are looking at Kalihi Palama and Chinatown with their significant issues with crime and with homelessness. We're working with the city, we're working with residents, business, community members to try to revitalize the weed and seed effort there. The seed effort has been trying to work all the time, but you need to have weed and seed. We're hoping to start that at the end of May. That is the goal. We're working with banks and other people about doing a survey of the area. Part of the weed and seed strategy is you go and you ask the businesses and the residents, what are your big crime problems? I did that when I was U.S. Attorney at Ka'iolani Elementary School, when we had stew and rice and the community was there. Well, with COVID, we can't do that. So we're going to try to work with folks, get a survey done, and get their issues on that. At the same time, we're working with the judiciary, we're working with the police department to work out procedures for the arrests. But that's only part of it. We recognize the homeless problem is bad there. Many of the homeless have alcohol, drug, mental health problems. Because of my background with drug court and Hope Probation, we're working with all of the drug treatment programs about taking in some of the chronically homeless into their programs. Because unless they get help with their behavioral health problems, they're not going to get better. You can put somebody in housing, but if they bring their friends in there, they're smoking crack or ice in there, they're going to get kicked out. We need to give them help with that. So it's really a two-pronged approach. Trying to clean up Chinatown, making sure the crime gets reduced, working with all of the partners to do that. But at the same time, it's helping the homeless. It's helping the mentally ill. I was happy to see that bill passed about getting help for the mentally ill with some court-ordered treatment, replacing the public defenders with guardian ad litems. If our office can help out in that effort, we will be doing that too. Because we realize there's some poor wretch on the sidewalk in Chinatown has a drug problem or one we can see, but is clearly mentally ill and is howling at the moon. We want to try to help them too. So we do have an outreach community court that has been worked on in many communities. We will be doing that in Chinatown as well. That helps defendants clear up their pending cases about sleeping in the park or on the sidewalk, as well as all the bench warrants they have, and help the judiciary that way. We are going to give the LEAD program, Law Enforcement Assisted Diversion program, in Waikiki. We're going to be working with HPD, and we're going to be working with the Health and Harm Reduction Center in trying that. We want to try different approaches in different areas because not everybody's the same. The homeless population is not a monolithic group. Whatever we can do to help them, we want to do that. And finally, as I mentioned earlier, we want to make policy decisions based on data and research, not based on anecdote, gut feeling, or the dreaded, we've always done it this way. For example, for 30 years, the prosecutors have had a rigid no-drop policy for misdemeanor domestic violence cases. And I think there was a good reason when it started. Before that, the police would not make arrests, they'd tell the guy to go sleep it off, that kind of stuff. So the police started a mandatory arrest policy. Around the same time, the prosecutors started a no-drop policy. So almost all the cases would get charged, and they would march forward and do the case regardless of whether the victim wanted to proceed or not, regardless of whether essentially they could prove the case beyond a reasonable doubt. That's the way it's been for 30 years. When the city auditors, unbeknownst to me, the city auditors had done an audit of our domestic violence unit 3 years ago. My second week in office, I got a letter saying, hey, can we come and follow up on that? So we said, okay. But one of their recommendations is look at that no-drop policy and possibly suspend it. So we looked at it, and we looked around the country at best practices, and we discovered we were one of like 3 communities in the entire United States that was still following a rigid no-drop policy. So we talked to our victim witness counselors. We talked to the members of the domestic violence world in Hawaii out there, including the Coalition Against Domestic Violence, including the Domestic Violence Action Center, to say, we're looking at this fresh, we're looking at this for best practices, and we are modifying that rigid no-drop policy. I always thought it was paternalistic for this office to say to the victim of a domestic violence case, yeah, we know what's better for you than you do. You know, she's the one, usually she, not always, but she's the one who knows, is she going to get beat up if she shows up in court? Is she or her kids running at risk of getting killed? So we are going to listen to the victims, and we're going to make sure if we go to court on a case, we can prove the case beyond a reasonable doubt. So that's an example of trying to look at it and follow our ethical obligation. We are also going to be working on the entire pretrial detention system, including cash bail. I have always felt it is unfair to poor people, and at the same time, it does a very poor job of supervising some of the people that need it most. Somebody could have the worst ICE problem in the world, but if they can put the $3,000 bail up for their burglary or whatever it is, they don't get drug tested, they don't get supervised. This is a complicated deal. Because I've been in the system so long, I fully understand. It's easy to say, oh, let's get rid of cash bail. But in order to do that, it affects other parts of the system. So when you change one part, you've got to change the rest of the parts. But we will be looking at all parts of the system, hopefully to do a pilot, maybe go to the legislature next year with some funding. Because when you put more people out there and have fewer people in jail, that is going to mean more people need to get supervised by Intake Service Center. And we had a very successful HOPE pretrial pilot that kept people on pretrial longer. They got convicted of crimes less often. They got arrested for new crimes less often. But part and parcel of the pilot we did was there was money in the HOPE treatment group for residential and outpatient treatment. So an example I have always pointed to is the Washington, D.C. Pretrial Services Agency. I dare say Washington has more dangerous defendants than we do here in Hawaii, and yet they are able to release most people pre-trial. They show up. They don't get convicted of new crimes. I think it's a really good model for us to follow. But what we want to do is work with our criminal justice system partners and our community partners to try to design a system that protects public safety and yet is fair to defendants and hopefully have fewer in jail. So that is what our plans are. I hope to be able to maybe come back with you folks like every 4 months, talk about what's been going on, give you a chance to answer questions. I know you're going to call up in between with certain things, but we are trying to be as transparent as possible. Some things we can talk about, some things we can't. Are there any questions I can answer now? Yeah.
You mentioned drug testing not being done. And why is it not being done? And what are the consequences you're dealing with?
Well, I think in the past, if you try to do HOPE probation, there's some people that are going to test positive. They need to go to jail. And if the jail was kind of shut down for a while and they didn't want to have anybody new there, I think that was part of the thinking behind it. That if you catch people doing something wrong in a program like HOPE, there have to be consequences. Now that the jail is, been testing everybody, they've been offering vaccinations to everybody, I would hope that process can get started. That means the courthouse opening up for business again. Right now it's not, I'm talking circuit court, it's not open to the public. And in order, for drug testing, when we were doing HOPE probation, we had maybe 2,500 felony defendants in HOPE pre-COVID. And they would call, most of them were on a drug test hotline, they would call that. More than 1,000 people were calling the hotline every day. More than 100 had their colors called to show up for testing. Of that, only 4 tested positive. So it really helps these guys to stay sober. But that means they have to come in to get drug tested. That means 100 people going in there. The courthouse has to be opened up for business. They are doing some testing, but it's very limited. So I know the Supreme Court's latest order was that status quo would stay till June 8, I believe. My hope is with the jail back operating, and their numbers have not skyrocketed, their numbers have stayed pretty steady. I think at the height of OCCC, they had 1,200 plus defendants there. There are 800 some now. It stayed relatively stable the last several weeks. We will be, when we're doing weed and seed, we don't anticipate that, except for some homeless people, maybe, or others with drug and alcohol problem who get arrested for felonies. For the misdemeanors and petty misdemeanors, we don't intend for that to put a strain on OCCC. Yeah.
What kind of data will your office be putting out about the number of charges you file, the kinds of charges, convictions?
As many as we can. We're trying to work with our PBK system to see what data we can pull out. We'll see if we can compare it to the past. The last year has been kind of a lost year with this. Typically, this office would bring like 2,000 new felony cases. I think last year it was 1,000. Those numbers are going to go up. And we're going to be pretty aggressive about things, but be smart about it too. We will try to be as transparent as we can about the number of cases we're doing, the convictions we get. It's a thorny issue about, we're trying to identify certain racial categories. When we met with OHA, we asked them, send us how you would like this broken down. Because we don't want to do this and put it in place and 6 months later have you call and say, why don't you include this? But it's tricky because, some of these mainland things, and if HPD works with the FBI, they have one category for Asian and Pacific Islanders. What's that, 70% of Hawaii, right? Not very helpful. We need to break that down. But we have to explain to different groups, we don't deal face-to-face with defendants. We get our information from HPD. So it's how they collect the data. We've had that conversation with them already. We will continue to have that. But is that part of the booking process? One way or the other, we're going to figure out a way to get that information. And we will try to be as transparent as possible about it. It's not an easy thing. One of the things we've discovered that's a challenge is our system does not interface with HPD. So even though they include a lot of information on each defendant, our poor staff members have to re-enter all of that information. So we are working actively on that. We put in a grant for it, but we're trying to work with them on it so that interface works, because our clerks are very hardworking. When anybody says anything about lazy state or city workers, I tell them, stop right there. You're not talking about our office. But they should not be re-inputting the same information. That is ridiculous. And so we're trying to do that just to make things more efficient, but also to save the burden on some of our staff members. Yeah.
Have any attorneys come forward asking to have their convictions overturned because Catherine Killow was the prosecutor?
No. And I think it's going to be one of those things that, she was a division head. If the case just got passed on to something else and she didn't touch it afterwards, the question's going to be, if they have credible evidence that she was actively involved in a case, all they have to, and they have concerns about it, they should be calling us up and we will look into that. We don't want anybody to be convicted of something. We met with the Innocence Project and talked about it. And we told them, if you have credible evidence of a case that you think somebody was unjustly convicted, send it to us. As ethical prosecutors, we don't want anybody in prison who was unfairly convicted. So we're happy to look at that too. They'll follow their own procedures, but if they want us to look at something and have credible evidence, then we will look at that too. That's part and parcel of doing the right thing. But, you know, it's a new administration here. I'm sure we will hear from some defense attorneys, but it can't just be, oh, Kathy Kealoha was somehow in the vicinity of a case. There has to be something showing that she was involved and maybe something improper was going on. But if we hear that, we will look at it, and if it turns out to be legitimate, you know, it could even be a prior guilty plea or sentence gets undone. We have no interest in people being unlawfully convicted. Yeah.
I know there's been some criticism of home probation in the past that, you know, it's become a revolving door for criminals. And is this an improved home probation that you're...
Home probation has always been effective. We have the data to show it. People in Hope get arrested for new crimes compared to a control group 55% less often. And they go to prison half as often. The data is clear. Now, there have been a few places on the mainland that have tried to do it. They saw it as only a sanctions program. They didn't have POs who cared. They didn't have judges who cared. Sorry. So they got mediocre results. We, from the beginning, have had great results. You say to me, it's a revolving door. Like somebody in Hope tests positive and admits it. They get arrested on the spot. They're going to get 2 days in jail. If they were on regular probation, they wouldn't get arrested at all. There would be zero consequences. So if people don't understand the system, wow, 2 days might sound lenient. But understand, we're trying to do something different. We're trying to change somebody's thinking to change their behavior. So that person who tested dirty came to the courthouse knowing he or she had smoked ice and we're going to test positive. And then they're going to be given a choice. You test $3.85 rapid drug screen cup, pee in a cup. They're going to be faced, okay, you tested dirty, Joe, what's up? You want to admit to it? Yes. They get arrested on the spot, go to jail, 2 business days. If they deny it and say, geez, I don't know how that got in there, they're let go. There's a small chance, minuscule chance, that the cup was faulty. But when it comes back confirmed, they're going to get 15 days in jail. We don't want it, and if they run away and don't get picked up by law enforcement, it's 30 days in jail. 2 days, 15, 30. And we're trying to shape their behaviors so they take responsibility for it. And like I said, the data is absolutely clear. So if people are criticizing Hope probation, they either have an agenda, they don't understand probation, or they don't understand Hope probation. So I would encourage them, do your own research. It's out there on the internet. We can send you the data. Dr. Hawken from Pepperdine and now NYU, randomized control trial studies showing this work. Same with the Hope pretrial pilot. Very successful. You know, 40% fewer arrests for new felony cases. No, 14% fewer convictions of the instant offense for a new felony case. 40% fewer arrests for a new crime during the pretrial period. There's no question that Hope is successful. If people have an agenda or they're looking at the mainland, they can do it. But to me, if they can't do it on the mainland, that's their problem. We can do it here. We get good results. And because Hope is so big, one judge supervising 2,000 offenders, that means literally thousands of people have succeeded on Hope because they were in Hope and not in regular probation and didn't go to prison. Because they go to prison half as often in Hope. And Native Hawaiians, we ask them to look at them. Native Hawaiians get their probation revoked and go to prison 42% less often in Hope than in regular probation. I cannot think of anything that would cause a family to sink into poverty faster than mom or dad going to prison. So because Hope is so big, literally hundreds of Native Hawaiian men and women have succeeded on probation because they were in Hope rather than regular probation. It is a home run. 10% recidivism reduction in criminal justice is time to pop the champagne corks. We're talking 50%. So if, you know, Please refer them to me. We can send you guys the data. It's very frustrating to have data showing this works, and yet people don't want to look at it, or they've got an agenda, or some people just don't like anybody spending 1 day in jail. But I think if you talk to the defense bar, talk to Miles Briner, talk to Rick Singh, the heads of the Hawaii Criminal Defense Lawyers Association, they'd rather have their clients do 2 days, 15, 30, 2, and not 5 or 10 years in prison. So, it is an absolute home run, and we will continue to do it. We'll do it right. Hopefully, we can do a whole pretrial pilot again. They're under new management. The results were so good last time. We look forward to doing it again, hopefully with Max Otani.
Steve, I wanted to ask you about an item in the news from yesterday. Hart hired Colleen Hanabusa as a consultant, which is raising some eyebrows because the job description exactly matches her resume. She's the only person to bid. Of course, bid rigging is illegal. So I was curious if your office is looking into this.
I haven't looked into that. I don't think anything's happening yet. So, nothing at this point. Yeah.
Kind of in light of this backlog that you're talking about with all these COVID cases, where do we stand now in terms of a lot of these hundreds of minor infractions that were issued in the past year, and some of them with these severe cases? The Surgeon General, for example, that made headlines, or the elderly couple that was stopped in their car, things like that. Have we gone through a lot of those, and will a lot of those be dismissed?
Our misdemeanor division, led by Florence Nakakuni and Leah Takeuchi, are looking at all the cases as they come in, as well as the existing ones. Some cases have already been dismissed. We are going to have to prioritize the more important cases. Some other cases will go by the wayside, because otherwise you're going to get the more serious ones dismissed. And we're trying to figure out a way to do that. Our new approach to the domestic violence misdemeanors, because that's a big backlog too, I think will lead to us going on cases we can prove beyond a reasonable doubt. But I think Chief Justice Rechtenwald said like 6 weeks or 2 months ago that at that time there were more than 1,200 jury trials backlogged. At least they're doing jury trials now. They use the criminal arraignment court in district court to pick the jury. They pre-screen people. They're bringing 34 live bodies, but it can only be single defendant cases. And then they farm it out to whatever judge is going to do it for trial. But we're going to have to be ready. Things are really going to be busy in circuit court. No doubt, as usual, we will be making agreements in different areas, but hopefully we'll be doing it from a position of strength, and we can protect public safety that way. But no question, especially in district court, we are really going to have to look at our resources, look at our priorities, and decide how we can move ahead.
In general, though, with some of those misdemeanors, like there's some of the headlines where it did seem kind of severe for just people in the height of the pandemic just walking down the street or something that minor. Is that something that should be maybe?
Over the history of the pandemic cases, most of those have been dismissed anyway. They're really looking at it, and part of it is you've got to decide, can you prove the case beyond a reasonable doubt? And if you can't do that, we're not going to go ahead with the case. So I know the legislature was looking at making a fine on cases instead of a full misdemeanor. People wouldn't get a jury trial. That may be a smart way to do it and deal with it. And I think HPD is being more selective in who they're looking at and who they're citing. But we will work with them going forward on that and with the court system.
And what about minor drug offenses too, like possession or things like that? Is that something that we should?
Well, I'm a full supporter of the decriminalization of marijuana. It's not as serious as the other felony drug cases. I'm not in favor of legalizing methamphetamine or cocaine, heroin, but I think we should try to reduce the collateral consequences of that. I'm a big believer in people getting deferrals on it, but I also believe that left to their own devices, if you walk down to Chinatown right now and ask the guy sitting on the sidewalk, do you have a drug problem? No. Do you need to go to treatment? No. I believe the leverage of the criminal justice system can help folks deal with their drug and alcohol problems. And if we can do that in a way they can keep their records clean, we are all better off doing that. But we're being hurt as a society by people with drug and alcohol problems. I appreciate all the efforts every group has made, Housing First and the like, but I really believe we have to deal with the behavioral health problems or they're not going to be successful in housing.